So good afternoon. I'm Giacinto della Cananea, and I'm very grateful to Professor Varga, as well as to his team, including Lilla Berkes and the others, for the invitation. Unfortunately, this time it was not possible for me to come to Budapest, and I apologize for this, but that was due to other commitments, and I hope that there will be another chance soon. So in this short presentation, I would like to make 4 points about the relationship between Italian law and the legal order of the European Union. As a first point, I will argue that there has been a path of gradual acceptance of the limitations of sovereignty stemming from European integration. And I will focus mainly, but not only, on the case law of the European Court of Justice and the Italian Constitutional Court. As a second step, I will argue that especially since the 1980s, the initial relationship of coordination has evolved into a clearer integration, and that is not only due to the case law of the Italian Constitutional Court, but also to the changes that have occurred within the Italian Constitution. And in this respect, there is an important role that has been played by the interaction between the two courts. Thirdly, I will focus on one important element of our research, which has been pointed out by Professor Varga in a previous seminar, that is to say, how is the relationship between national and European identities conceived in Italy? And fourthly and finally, I will briefly discuss some controversial or critical issues that have arisen in recent years. So let me begin with the first step, that is to say, the initial adjustment to European integration. And in this respect, it can be helpful to briefly share on the screen few slides that I have prepared for this workshop for two reasons. First, because in this slide there is a reproduction of Article 11 of the Italian Constitution. And secondly, because it allows me to better explain the importance of the political support that was given to European integration. From the first point of view, as you can see on the screen, on the slide, Article 11 of the Italian Constitution has provided since 1948, when the new constitution was adopted, that Italy would agree on conditions of equality with other states to such limitations of sovereignty as may be necessary to ensure peace and justice among nations. And that Italy would also promote and encourage international organizations pursuing such goals. Now, in this respect, there was very important change with regard to the ideologies and political practices and governmental practices of the previous period, because until 1945 in Italy, there has been a prevalence of autarky, so the idea that Italy could do alone, as well as of authoritarian government. And when the famous Schuman Plan, that is to say, the speech given by the French Minister of Foreign Affairs, Schuman, was made public in 1950. The Italian government was one of the first one to agree. And there was, 2 years later, a famous speech by Alcide de Gasperi, the man you can see on the picture on the top of the slide, according to whom the idea of the Italian government was that in Europe we were building a coalition of democracies founded on the principle of liberty. That was arguably the prevailing idea, which was not without difficulties, of course. So in the 1960s, the Italian Constitutional Court found it hard to accept the primacy of European community law in the Costanera case. And more or less 10 years later, in the Frontini case, they came out with the theory of the counter limits to the primacy of European community law in order to preserve the fundamental principles of the national constitutional order. And that took place in the same years in which the Zoll-Lange doctrine was announced in Germany by the German Constitutional Court. But in the following decades, there were important revisions of that constitutional doctrine. First of all, because the Constitutional Court, in a series of important judgments, beginning with the La Pergola judgment of 1984, revised the initial doctrine according to which the Italian and the community legal order were separated, by affirming that the two legal orders were autonomous but coordinated. And 5 years later, in 1989, the court clarified that the two legal orders were not just coordinated, but also communicating. Now, arguably, the Constitutional Court gradually changed its jurisprudence. But at the same time, we have to take into due account the steps taken by politicians who changed the Constitution twice. The first time in 2001, as you can see from the second slide, by clarifying that national legislation shall respect both the Constitution and the legal order of the European Union. And even though that does not imply, at least for some constitutional lawyers, that the Constitution and the legal order of the European Union are put on the same place, on the same footing, but still there is awareness that legislation must respect EU law. And secondly, more recently, in 2012, the Constitution was changed again in order to clarify that the principles concerning budgetary law and more broadly European and national finances are the same. So, for example, the national budgets must be balanced and public debt must be sustainable in accordance with European Union law. So, what are the consequences of all these? I would argue that there is nowadays an even stronger and more specific legal basis for the primacy or supremacy of European Union law, even though the Constitutional Court has repeatedly affirmed that the fundamental principles of the national constitutional order must be respected. And interestingly, after the constitutional revision of 2001, there has been an acceptance by the Italian Constitutional Court of what is called, a bit generically, the dialogue between the courts. So in a first case in 2008, the Italian Constitutional Court sent a preliminary reference to the European Court of Justice. They did it again 10 years later in a case which was much more controversial, because while the first case was a simple one concerning regional taxation, and it could also be argued that the Italian Constitutional Court used instrumentally European Union law in order to declare the unconstitutionality of national legislation. In Taricco too, which was a controversial case concerning the protection of the financial interests of the European Union, what was at stake was, according to the ordinary judge who raised the issue and brought it before the Constitutional Court, a much more important norm, that is to say, the national constitutional tradition, according to which criminal trials must come to an end after a certain number of years, what is called prescription in Italian law. So interestingly, the Italian Constitutional Court refused the opinion according to which they had to declare that there was a contrast between the European and national traditions. And they sent again a preliminary reference to the European Court of Justice. And the upshot of all that was that the emphasis was not placed so much on the national constitutional tradition, but rather on the possibility to have a more pluralistic conception of constitutional traditions. So in practical terms, the Italian constitutional tradition was viewed in accordance with a common constitutional tradition. More recently, there has been a third case, this time concerning administrative sanctions in the field of financial markets, and this case concerned the right to remain silent during an administrative procedure. It is what is called, with an old Latin or Roman expression, nemo tenetur sede tegere. And once again, the two courts agreed that there was no contrast between the national and the European traditions. So, coming to my third point, what can we learn from these changes that have occurred both in the case law of the Constitutional Court and more recently and importantly in the Constitution itself? Well, I would argue that there are two elements that must be considered. One concerning the initial participation of Italy to the communities, and the second concerning how the concept of national identity is interpreted by most, though not all, constitutional lawyers. From the first point of view, this is something which already emerged during the previous workshop that we had with Professor Varga and the other members of this group. For post-war Italy, being a founding member of the European communities was certainly a fundamental element in the process of building the new polity, which is also the reason why it was accepted by the majority of Italians and of their political parties, while there was at that time in the 1950s a strong opposition coming from the political minorities, at that time the left. That element for Italy, as well as for Germany, being a founding member, is really something which has a fundamental importance in defining our national identity, which explains why when a debate has emerged in Europe concerning the meaning and significance of Article 4 of the treaty establishing the European Union, according to which the Union shall respect the equality of the member states as well as their national identities, that clause has been interpreted by the prevailing majority in two ways. On the one hand, in the sense that Article 4 has established what could be called the principle of mutual tolerance, in the sense that differences between national legal systems must be accepted if they are compatible with the values and the general principles upon which the European Union is founded. And in this sense, the interpretation proposed by Professor Weiler and Professor Cartabia has been shared by many constitutional lawyers. And on the other hand, both the case law of the Italian Constitutional Court and the works of learned interpreters such as Giuliano Amato, who was the president of the court until a few months ago, suggests that the interpretation of the national and the European identities should proceed in a coherent manner, in the sense that even though respect must be paid to certain specific features of the Italian constitutional order, so much of our national identity depends on the common construction of the European identity, that the possibility of conflicts remain potential, but is very hard to occur concretely. And interestingly, and this is the final comment that I want to do in this presentation, there's a contrast with the doctrine which has been defined by the Constitutional Court in recent years, in the last 10 years, with regard to international law. So while in other countries there has been some reluctance to give a special status to European Union law, in Italy, in the case concerning the German liability for the damages that occurred during the Second World War, a contrast has emerged between the Italian Constitutional Court and the International Constitutional Court, and in the sense that the Italian court argued that the possibility of having judicial protection, an effective judicial protection, is a defining element of the Italian constitutional order, which does not allow judges to give up the actions that are brought, which are still being brought by Italian citizens against German authorities. So in this respect, we could say that there is some reluctance to ensure the respect of international law, while nothing similar has emerged with regard to European Union law. And that is the reason why also the proposals that have been made in recent years by some political parties to revise the Constitution's references to the legal order of the European Union, as they were done in 2001 and 2012, in my view, should not be taken as implying that such a change will necessarily occur in the next few years. So just to sum up and conclude, what I've been trying to show is that there's a process of gradual construction of a relationship between the Italian legal order and that of the European Union, which is based on integration. And that as a consequence of these, also the process of building the national identity is not dissociated, separated from the building of a European identity. Thank you so much.